Good evening, everybody. Thank you for joining us on another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela, and our special guest this evening, Julio. First time to the show, we welcome Gary Miller.
Thank you for having me. I'm excited to be here.
Absolutely, man. This is going to be a great show. Julio, what have you been up to this week?
Oh, you know, fighting cases, taking care of kids, fighting cases. I was thinking...
Are your kids fighting with you, too?
Kids fighting, yeah, I'm having to, yeah, no, it's, you know, I was thinking, down at the courthouse, every day, we have the most important cases to our clients and to us. And every day we're down there having to know 2 or 3 moves ahead of what we think the opposing counsel's thinking, 2 or 3 moves ahead of what the client's thinking on every single case, every second, and you can't make a mistake. And this week has been particularly busy for me, and it's just good to just take a break for like an hour and just talk a bunch of jazz about this and that. I'm excited about the show.
We got a great show.
We got a great show. Gary's coming on, and it's going to be good.
First time on here, but we're going to be with you for the next hour, ladies and gentlemen. We got a lot of great topics to discuss, a lot happening this week, both locally and across the country. We'll be with you for the next hour. Like I said, we'll take your phone calls starting at 8:30. 713-807-1794 is the number. Also have Twitter up at HCCLA_TV, so you can hit us up there with your questions and comments all night long. Let's start, guys, with what happened this week in Austin. Our new DA goes up to Austin, and she's there testifying in support of a bill to change how witness bonds are handled. And of course, this bill stems from what happened last year, where the DA's office under the old administration had a rape victim jailed pursuant to a witness bond because they felt that they weren't going to have her available for trial. Well-publicized case where trial started, there was a break, they were concerned she was going to leave. You had the whole Christmas holiday where she ended up spending Christmas in the jail. It's become a national story, of course, and now it has come to Austin in the form of a bill to try and reform the witness bond law and what's on the books and how a prosecutor can move to hold a witness in custody. And Gary, I know you were a former prosecutor for a couple years. What do you think about this bill? The proposal, is it really going to be meaningful going forward? The changes that they're proposing.
I think it will. Witness bonds are not used very often. I mean, you do not see them unless it's a serious case, typically. You rarely see them. And there really was kind of a mystery surrounding how it was done, what you had to do, what requirements you had to meet. I've seen prosecutors do things like, hey, let's have a meeting next Thursday at 8 p.m. I want you to be at my office to talk to me about this case. Of course, the time would come, the witness wouldn't show up, and they take that as, strike one, this witness is not going to cooperate. Then they do the same thing the next week and say, hey, I want you to be here Tuesday at 2 p.m. We're going to talk about the case. Then they don't show up again. Then they run and they get the witness bond, and the witness is thrown into custody.
Yeah.
And they don't have a lawyer. My understanding is now that, I guess, notifications are going to be made, setting off kind of wheels in motion to make sure they have a lawyer, certain safeguards that they're not sitting in jail with no one representing them. Obviously, I think this was a big political issue for the election.
Sure.
I mean, she had to follow up with this. I mean, she used this to her advantage, basically.
No doubt.
Which, I don't blame her for, but, she, I think, had to follow through with this and see it through.
Yeah, it was interesting. Her comment at the hearing was, she said it's not that what the state did was necessarily illegal, but it was unfair. I mean, that's 100% accurate because...
That's right. I don't know the status of the lawsuit. I assume it's still going. I assume she doesn't want to admit that the DA's office had some kind of wrongdoing in that pending lawsuit. I think it's still pending. But she also is kind of still doing the political thing and saying, hey, I understand this is not fair. I mean, rape victims are not supposed to be thrown in jail and forgotten about.
I mean, that becomes the issue is did the DA's office actually follow the law the first time? There seems to be some questions about whether or not they did. But setting that aside, whether or not they followed the steps appropriately or not, I don't think that you can say just to eliminate witness bonds altogether. I don't think that that's a good scenario, because I mean, you should, the state, I mean, I can't believe I'm advocating for this, but as a defense lawyer, but I mean, I think there should be something. I mean, as a defense lawyer, you want to be able to get your witnesses there, and you have the ability to have them attached and brought to court, because when you issue a subpoena as a defense lawyer, you expect that subpoena to be honored, and you expect the witness to come to court and testify, because your client's life depends on it, and so. What's good for the goose is good for the gander. But I do think that it was obviously handled in a very, very poor fashion with regard to this witness.
The witness bond bill was proposed by Senator Whitmire, and it adds particularly Section 6, which requires two things that are new, at least in my opinion. The first one is that a hearing has to be held in open court regarding an attachment of a witness, which I think would be pretty standard anyway. You have to explain to the judge as to why.
Didn't happen.
Right, and it generally didn't,
Yeah.
but you'd like to think that there'd be some sort of open process as to why a witness needs to be attached and brought to court to testify. One of the interesting things that the article or the bill does is it requires a hearing to be in open court, but now, if the witness does not reside in the county in which the action is proceeding, the hearing required by this article must be held in open court and in the witness's county of residence. So interestingly enough, if I'm trying to get somebody in from Dallas or from Cameron County, and I'm trying to attach them from there, a hearing would have to be had in that witness's county
Yeah.
to bring them over. And so because of that, the second part comes in where the bill would require that individual to be represented by counsel, which is great now, because if, let's say it's a witness that's adverse to me and they have counsel and we're going to have a hearing, I might be able to cross-examine them on issues that might be material or relevant to my case.
I think the big issue here with Jenny's case was she had mental health issues. One. Two, when she got into jail, nobody even knew where she was. Like, she was basically lost in the system. She was thrown into general population and, tagged. They thought she was actually a defendant.
Right, and it came into the holidays were then. I mean, it was
Yeah.
kind of like the perfect storm of, she really was, I think, forgotten in the jail. They
Right.
didn't know who she was. I think one of the articles referenced the jail might have even thought she was the person accused of sexual assault.
Exactly.
As opposed to being the victim. So obviously the communication was not there. Whenever the witness bonds are used, that person usually is a very difficult witness, typically, that they are, adverse, or they've changed stories, or they've been uncooperative on occasions. So usually they really would benefit from a lawyer trying to advise them kind of through this process.
Well, and let me ask you this, Gary. I mean, if it is a witness who is problematic, who has changed their story, who has, been kind of recalcitrant to deal with from the DA's office, why would they want to call that person?
Typically it happens in a case where they need the witness. They have to have this person for whatever particular facts they can testify to. Like, they're the key eyewitness to the murder, or they're the victim in a sexual assault. Like, they really don't want to do that.
Yeah.
But there are certain witnesses that they have to have there. If they're the main witness, they're going to do everything they can to get them there, and that usually involves a witness bond.
Yeah. I mean, it's got to be tough if the only eyewitness is causing you a lot of problems, disappearing, changing their story. I mean, it's fertile cross-examination, obviously, for a defense lawyer, and makes the prosecutor's job that much tougher.
It is. The DA's office, I think it might have been Mark Brown, who's now a judge. I mean, he talked about, I wish all my murders, occurred in front of a church or in front of a bus full of nuns. He used to make statements like that. But in reality, it doesn't happen. A lot of people that see serious felonies happen are out there right where it's happening and have been accused or whatever.
And that's why so many, drug cases, possession of controlled substances, distribution cases. I mean, you're not getting, as you say, the people coming out of church that are seeing the hand-to-hand deliveries go down. It's the people who are actually, helping them do the deliveries and selling drugs with them. And so, I mean, you kind of have to take your witnesses as they come, right?
Yeah, I mean, you're stuck, and that's why the witness bond is out there.
Yeah.
Like, if I need this person here and they're going to flee, then I've got to do this.
We see a lot of this, or at least I see a lot of this in assault family member cases, where the government, let's say, has a 911, and the 911 says, come quick, he's beating her up, or he's beating me up, and he's breaking my wrist, come quick. And maybe they don't take any photos, and maybe they give a statement. And come trial time, that individual's not going to come testify because maybe she made it up, maybe or he made it up, or maybe she's suffering from battered women syndrome, or maybe for whatever reason she's not, on her own personal motives or his own personal motives, they're not going to come and testify. So, as a defense lawyer, in trial, all we're left with is this horrible allegation, no photos, but a terrible, terrible 911. And you would like to just tear into that witness to talk about how all the things that were said on the 911 aren't true. All the things that you said and the descriptions that you had could not have happened based on that 911 and the physical evidence and looking at all of it. However, if they don't come and testify, you're stuck with just a horrible 911 call. And for whatever reasons, you may not want to put your client on the stand. And so then what are you left to do? Because just recently, a case came down where Jason Long was the defense attorney. Congrats on that. They got a reversal on a Crawford issue. However, on a side issue, the Court of Appeals said that 911 calls in scenarios where the incident is just happening, they're not confrontational and therefore can be admitted into evidence. And so the idea that you should be able to cross-examine the individual on the 911, if they don't show up, you're screwed. What are you supposed to do?
Well, I mean, I think and I haven't read that opinion, but I'm guessing that you could make the argument, and I don't know if they did in that opinion or not, that it's an excited utterance, so it's an exception to the hearsay rule, and they probably looked at it and said, the confrontation clause, you also have the right to confront and compel witnesses, meaning you can subpoena the person who was on the 911 call.
And attach them. If they got to.
So as much as you have a constitutional right to confront and cross-examine your accusers, you also have the right to compel process, to have those witnesses come. And if they don't want to show, you have the right to get a writ of attachment.
And Julio on the defense side, always been a big fan of not making that person come and being just left with a recording. I haven't tried the opposite of forcing someone to be there. But that's all just strategic, I guess.
Right.
Depending on the facts. If there's no photos, I think you're in good shape with nobody showing up.
Right.
It's even harder with photos, but.
Right. Let's say you have 911 and photos, and one of the things that always happens is, and it happens over and over and over. They'll allege, let's say the manner and means of the assault is by a punch. However, the injury is obviously not a punch. It is a scratch, and you'd love to cross-examine how some punch looks like a scratch, but you can't. And so the jury ends up being confused and generally will sometimes convict you on the individual that an assault occurred.
And I read that case today. I think it was today, right?
It came out today, yesterday.
And they went through a long discussion about the 911.
Right.
And it appeared to me that the alleged victim even left the original scene
right.
and then called 911. And they still found that that was an excited utterance and
Yeah.
still was not subject to
Right.
confrontation clause,
That's exactly right.
which is
Well, because the right to secure compulsory process is part of the same amendment. The confrontation clause and the right to compulsory process, it's all part of the Sixth Amendment. And so, I don't think you can say that the confrontation clause supersedes and vice versa. I mean, if you look at it and you say, well, okay, I mean, we've now found an exception to the hearsay rule, which allows it in because it's an excited utterance. Yeah, you have this right to confront the witness, but at the same time, within that same amendment, you have the right to compulsory process, to bring that witness to come. And so, I mean, there's no distinction between
and
the two.
traditionally
Which one trumps?
within the DA's office on family violence cases, they have not gone the route to go and get a witness bond or to try to throw that alleged victim in jail. Just traditionally, they've left them alone.
That's the
And they have not pursued any kind of witness bonds against alleged victims of domestic violence.
That's one of the biggest things. Our fears are, well, if I don't show up to testify, are they going to come arrest me? I don't see that happening in misdemeanors. On a big giant murder or a rape case, a serial rape case, yeah, I think that might happen. They're gonna issue a writ of attachment and come get you. But I don't really see that happening on the misdemeanor level.
And it's been that way for a long time, and I don't think it's going to change. I don't think they're going to start doing it. So we're going to have to continue with the same issue about the confrontation clause.
Yeah.
And what are we going to do as defense lawyers?
In Jenny's case, that was a serial rapist.
Right.
I mean, had it been what you're talking about, a misdemeanor assault case, a domestic violence case, maybe even if it was just a one-off felony sexual assault case, this might not have happened to her. But I think you're right, Julio. I mean, I think that the fact that you have a serial rapist, somebody that they really need, and going back to your point, Gary, about how, in that situation, they may not have even been able to locate other witnesses. And she may have been the only one that they could even locate.
And
so
I
they're
think
stuck
that's
with that.
part of what the DA's office was trying to say when
Right.
it all kind of the story broke was we didn't want to do it this way.
Yeah.
This is the only way we could come up with. This is the only
Exactly.
witness we had. I mean, obviously it didn't work out that way.
No,
I
it was
at least-
handled very poorly.
Correct. I hope they didn't intend it to happen that way.
No.
But it started out as, I believe, from good intentions and like we need to prosecute this person.
Well, let's flip it on its back and say, okay, this seems like a good idea. However, what if I need a witness out in Cameron County? And according to the statute or the proposed legislation, the county where the witness resides will have a hearing. And that judge down in Cameron County or wherever says, nope, sorry, this witness isn't going to be attached. And I'm like, I need this witness because they're going to present a 911 and photos up here and it's going to destroy me. I don't see anything in the proposed legislation as a remedy for that. I mean, so then we're just,
Well, wouldn't you have a right to appeal?
I don't know. I mean, on the order
On the
not
order of
honoring the
Yeah,
attachment.
on the order denying attachment, wouldn't you have?
I'd
wouldn't-
imagine.
Wouldn't you have a right to appeal that?
Would it be an immediate appeal or something
it's-
you'd like to think it would be something that would
think.
be what's called interlocutory for
Yeah.
the viewers, right?
I mean, you would think that it would have to be an interlocutory appeal because, you have if you can't get that person there, you have an immediate harm.
I agree.
So
I don't know. Unless you can maybe somehow bait the witness to come to your county, serve her there. Yeah, and then no. I mean, I don't know. I'm just thinking,
I don't know either. I mean, it's an interesting discussion. I mean, there's a lot of moving parts to it. I mean, I think this bill is a good step, but look, nothing about this is ever it's not going to ensure, I don't think, that something like this never happens again.
Right.
Because I don't think you could ever, this was such a one-off case, but I don't know that you can amend the statute or create a new law that completely prevents it from ever happening again. I mean, stuff falls through the cracks sometimes and things happen, and unfortunately, but that's what the civil justice system is for. because I do think, while to your point, Gary, they may not have intended to do this. I think they were grossly negligent in how they handled it.
Oh, I 100% agree.
You know,
I mean,
so-
she really was lost at one point.
Yeah.
I don't think they had any idea where she was.
Yeah.
And she was in the jail somewhere, but who knows where.
I don't even think they knew where it was either, right?
And we don't know why she's in there.
Right.
Basically.
So that's just it's
which scares me.
I know.
It's a giant jail. I don't understand how they lose somebody.
I think Nick's working in San Antonio now. I don't know. Is it the Bexar County DA?
Yeah, that's what I've heard.
I don't know.
We'll see.
But yeah, I don't know.
Well, we'll keep track of this bill and see. You know, I'm sure it's going to get passed. I can't imagine it's not, because the what brought it here was such bad facts.
I think it's out of committee. Yeah.
Speaking of bad facts, let's move to this ruling by the 14th Court of Appeals this week in DWI cases. And we're going to get a little nerdy here talking about Court of Appeals opinions. And Julio and I probably aren't the best people to be talking about Court of Appeals opinions, but that's why we got Gary Miller here tonight.
Oh, I'm not the expert. I'm not an expert on appeals either.
We have our appellate expert.
Our appellate section is here tonight in the form of Gary Miller. So it's a little bit of a nerdy situation, because it's talking about this opinion is talking about what you need to prove in a second offense DWI. And for those of you, and the reason I picked this tonight to talk about is because there are over 15,000 DWI cases filed in Harris County alone each year. So it's a pretty prevalent crime, and I think people should, that people are charged with, and so I think that people should understand what the law is that the state actually has to prove against them. Now, this case dealt with a second offense DWI, and historically, up until this case that came out, everybody kind of viewed the fact that a prior DWI was something that the state had to prove up at punishment. The enhancement paragraph, so to speak, is what we call it around there. And that you had to prove that up at the punishment phase, not during guilt innocence. And the case went up, that was appealed by the defendant, which the court ruled, nope, you can't stipulate and keep that fact away from the jury, because you now have to prove it during guilt innocence, because it increases your mandatory, your minimum punishment from 0 days to 30 days. And Gary, you and I were talking before the show. I mean, I'm not surprised by the ruling, because federal courts have ruled that years ago, that any factor that increases your punishment must be proven to a jury. And so I'm more surprised that it's taken this long for a state court of appeals to find this. I mean, to me, it was kind of a nice little loophole that defense lawyers had.
Right, it was a loophole. I mean, we've had this in other cases. You know,
Yeah.
just take DWI example, DWI third, a felony DWI. The jury at guilt innocence, the first stage of the trial, would hear that you have 2 prior DWI convictions, meaning the prosecutor had to prove up those to show why you were even in a district court, a felony court, to begin with. So, and we see it in other cases too, you know, theft thirds. You also see it in, you know, felons in possession of firearms. They've got to prove up that you have a felony on your record to make it illegal. But yeah, I'm surprised too it hasn't taken this long.
Yeah.
I don't like the decision, obviously, but I can understand kind of the logic behind it.
Yeah.
I mean, DWI is developed over years and years and years, and it just keeps going more and more against the defendant. You know, there used a long time ago, there was if your prior was over 10 years old, they couldn't use it against you. Now it's forever. You know, you got your
Exactly.
DWI in 1989. Well, here it comes again. You're now
You got your
a second
DWI
offender.
in 1969. Here
Correct.
it comes again.
It doesn't matter. The years don't matter. They
Yeah.
used to at one point. Now it just gets worse. So now, you know, lawyers are going to have to deal with this in voir dire, obviously, and judges. It probably is going to be harder to get a fair jury, I would imagine.
So
That's one of the questions I had about, you know, is it going to lead to more busted jury panels?
I would think it's going to have to. I think it's going to lead to more busted jury panels, and when you finally can seat a jury, it's still, I think, going to stink. So prior to 2 days ago, when a defendant gets arraigned, an individual gets arraigned, they say, Here, 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 on this day, Joe Blow did therein commit the offense of driving while intoxicated against the peace and dignity of this state. And that's all you would hear. To which the defendant pleads not guilty. But now, as of 2 days ago, an individual will be arraigned like as follows. Here, here, Joe Blow did and then on such and such date commit the offense of driving while intoxicated against the peace and dignity of the state. And he's been convicted of DWI 2 years ago. To which the defendant pleads not guilty. But by the time the jurors hear he's been convicted of a DWI, this is his second one already? Are you serious? Forget this, he's guilty. And all the studies show that jurors tend to have made up their mind after opening. So you got voir dire and opening, the 1-2 punch. After that, jurors have generally made up their mind according to some studies. And so by adding this stink to the beginning, it's going to, at least in my opinion, make it very difficult to basically say, look, guys, all right, jury, client, he was convicted of a DWI 2 years ago, but this time, didn't do it. Didn't do it, all right? And so just ignore that. I think it's going to be very difficult for a defense lawyer to overcome that, or at the very least, as always, we're just going to have to get smarter, faster, stronger, more creative to attack those kind of issues.
I love the argument that I've seen defense attorneys make it all the time. When you get stuck in these situations, to turn around, if it's true that your client actually pled guilty to the first DWI, to be like, look, my guy claims credit. He takes responsibility for things when he actually commits a crime. And now this time, he didn't do it. So here we are.
Yeah.
And you've got to do something. You can't just say, yeah, that's true. I got convicted 2 years ago. I mean, you're going to be in trouble. You've got to do something more than this, that.
Well, and you could do the old stipulate and say, yeah, look, Judge, before he's arraigned in front of the jurors, we stipulate that he has a prior DWI in 2012. Is that out too?
You can't do that now. That's what that case says.
Oh, man.
You can't do it.
Because, I've done that before in other cases and have stipulated
Right.
on DWIs. But that's my reading too, is they're saying you can't do that.
You can't do it because it's now essentially the way this if I read the case correctly, okay, they're saying that this is now the enhancement paragraph is actually a factor that increases your punishment level, which it does, because a second offense DWI has a minimum punishment of 30 days.
Well, it's so you go to an A,
Right.
so it'd be minimum 90, so it'd go 90.
Yeah.
Yeah.
So that's what
90, yeah.
It increases the punishment
Yeah.
from that. So it's a factor that has to be.
no, it
proven.
Well, it won't be that
won't be.
anymore, right? No, right. It'll
can't.
be
You can't because you can't enhance an A with a class B.
Right.
So it won't be.
Well, I think you can. I mean, this would be something for a column, but I think, like, for example, if I'm charged with the class, it changes the enhancement. It changes the punishment ranges.
Yeah.
So we'll keep it that way.
You've got to do, on a DWI second, you've got to do 72 continuous hours in jail, as if you get probation or something like that.
Well, because if they don't prove the enhancement, isn't a first DWI doesn't it become the lesser?
It becomes a
It
lesser.
becomes a B.
Right.
Right. So if they can't prove the factor that increases your punishment from 0 to 30, in other words, if they can't make the leap and show that it's gone from a class B to a class A because of this, it's the first offense now is a lesser included charge. So it's an element of
the jury could find your prior conviction not true, basically.
Yeah.
And be like, hey, that you didn't prove that.
Right.
And then it would drop back to the class B, meaning you'd be facing 6 months and 2 counts.
Exactly. So I mean, they can make the allegation, but if they can't get the proper paperwork there or whatever to prove, the judgment and all that stuff, all the certified records to show that it in fact was a conviction, it's a first offense. Because it's an element of the offense, is what they're saying.
I'd really like to get one of our DWI. I mean, we have one, but like one of these DWI like specialist gurus to see how they're going to attack this new issue.
Well, I think Gary makes a good point.
I
with-
agree.
with how you handle it if your client pled guilty to the first one.
And I
Right.
think, you obviously, I wouldn't stipulate, I don't want to insult misdemeanor prosecutors, but you're going to have to make them jump through the hoops. They're
Yeah.
going to have to go get certified judgments. You're going to have to see if it's readable fingerprints. They're going to have to get a fingerprint expert.
Yeah.
They're going to have to do things called jail cards, which are records of people when you're in jail. And they're going to have to prove those things now.
Right, and so as a defense lawyer, even if I don't know, based on this, and I read it quickly, I don't know if you even can legally stipulate, but ethically, I don't know that you could stipulate
I don't know why you'd want to stipulate.
to an element of the offense.
I don't know why. Well, I mean, I've seen people stipulate to other, and I don't know why and one would stipulate. I don't know why one would stipulate. I mean, I guess for strategic reasons, I don't want to say in this universe, you should never stipulate to
I
anything,
did it
but
in
I
a
don't know.
felon in possession of a firearm one time because the actual indictment where it alleged my client was a felon was a terrible felony that he had a conviction for. Like, it just sounded bad when you hear the words. And so I didn't want that coming out in front of the jury.
Sure.
So all we agreed was, hey, we committed a felony on a certain date in Harris County, and here's the case number. We didn't say what kind of case it was. We just said it was a felony. And talking to the jurors afterward, they didn't seem to care, really. They didn't focus on it too much. They didn't, go behind the lines and try to figure out
Well,
what
yeah,
it
because
was.
sometimes the nature of then you're getting into a potential scenario where the nature of that offense is a potential 404B issue.
Right.
And that is a potential character issue, and 404B is a rule of evidence that prevents a prosecutor from admitting certain acts or wrongdoings for the purpose just to show that this is a bad person.
Oh, he wanted to read mine bad.
Right.
He was very
unless-
excited. He was calling the appellate division like he freaked out
Yeah.
when I said, hey, we're going to stipulate that he's a felon.
Yeah.
I mean, he was not appreciative of that.
Yeah, because otherwise, if it has no relationship, if it doesn't meet one of the exceptions of 404B of how it can be used, then you're just using it to show that he's a bad person, which you cannot do under the law. And so, this can be.
And you guys know, DWI are just, they're kind of their own special class.
They are.
And the jurors are like, hey, that could be me up there. By the grace of God, it's not. It's not when you're in a felony trial and you stand up and say, my client's charged with capital murder.
Right.
It's totally different.
Yeah.
People are thinking, that could be me. I did that last weekend, or whatever.
Well,
But now you got this whole other thing with the prior.
And I want to touch on that real quick, but I want to remind everybody we've reached the halfway point of the program, so we're going to open up our phone lines now. 713-807-1794 is the number if you want to jump in with any questions or comments for us. Also have Twitter up, been silent all night. Get them in here, get your questions and comments in, and we'll take them live on the air. You talk about DWI becoming kind of its own little creature, and it really has morphed into that. I mean, this is not something where you can just, as a lawyer, it used to be no test, no accident. It was, you could they were all kind of cookie cutter, stamp this, go in. It's become so scientific with now the blood warrants that are out there, attacking the breathalyzer devices, because a lot of people now have made the choice that instead of them poking a needle in my arm, I'm going to go ahead and take the breathalyzer. I mean,
Right.
10, 12 years ago, a breathalyzer, a breath test case was rare because the old adage was, don't ever submit to that thing.
Right.
And so the majority of people never did. And you'd end up with a ton of what we used to call no test, no accident DWIs. And, it was just basically proving whether or not getting the jury from a prosecutor's side to believe that the defendant had lost the normal use of their physical and or mental faculties, because there was no way in hell they could prove a blood alcohol level above a 0.08. They had to get that alternative. And so it really has become a creature of its own because of that. And I believe that between MAD and, all the things they do every weekend, New Year's, everything else, where it's no test, no act. Now
That's every day.
Now it's every
It's
day.
every day.
No test. If you no refusal weekend. I mean, not no test. No refusal weekend. It's now no refusal 365 around here. But all that has really reinforced, I think, that this is we have to punish these hard, and we have to take a hard stand. I think that it really has affected the jury pool on these things.
I mean, when you get hired on a client and they've been arrested for DWI, they get most of the time, typically they're above a 0.15 blood or breath alcohol, and they get stuck with so many conditions and rules and different things they have to do. I mean, I'm sure you guys have clients charged with far more serious crimes that don't have to do anything. And these DWI people they've got devices they got to blow into.
Yeah.
They got little backpacks they have to carry around. They got to call in. I mean, they have to do so many things.
But is it just me, or do you now, like, I guess I don't handle as many DWIs as I used to, but everyone that comes in my door now, they have just astronomical blood alcohol levels, it seems like,
I did a-
0.18 being like the lowest. I mean, then you get,
I think the Harris County average, I believe it's close to 0.20, I want to say.
Yeah.
I mean,
I
they've
think it
tracked the
is too. I
statistics.
think it's
I think
0.2.
it's 0.2 from the blood draws. That's the average.
right.
So I'm a 6-foot male, about 205. Tyler Flood hooked me up to an IV and took my blood, and we drank and ate, and drank and ate, and drank and ate. I had
That's what you call a Friday night.
right.
So, I mean,
that's what I call a good morning. No, I had 13 drinks in 3 hours, and I was hammered, and my blood alcohol level was a 0.15. 13 drinks, 3 hours, 0.15, and I was smashed. And I tend to drink. I was like, come on, hook me up, let's booze, let's do this. I was smashed at a 0.15, 13 drinks. And so when you see these numbers of 0.2, 0.25,
0.34.
0.3, you're just thinking like, what in the world? And I consume alcohol. I'm not an alcoholic. I consume alcohol. And so I think, those numbers don't really, they're not really in perspective. But no, 0.15, 13 drinks, 3 hours, hammered out of my mind. And these guys are coming in with like 0.2s and 0.3s.
Mm-hmm.
Oh man, I used to be like, oh, that number, forget it, you're fine.
You used to think
Yeah.
that number is so outrageous, it can't be right. It just can't be right because it is so ridiculously high. But the problem is, I swear to God, over the last year, it seems like every person that has come in my office on a DWI has been 0.15 and above. And it's like, what is going on out there?
I don't know, but I see the same thing. I mean, I haven't had someone at near a 0.08 or 0.09 in a long time.
I mean, Uber needs to do a better job with campaign at this point,
Smash, call a ride,
or
guys,
Yellow
come
Cat,
on.
whoever. I mean,
And with the blood results, it's so difficult already to overcome. If you're going to fight a DWI case,
Yeah.
it's already so difficult. And now they're going to be bringing in, and by the way, old boy had a DWI 2 years ago too.
right.
It's going to make it it's even that much more difficult
Yeah, it really is.
to fight and win a DWI case.
Speaking of difficult cases, let's move on to the publicized case this week of the murder for hire that tragically ended with one of the defendants, the veterinarian, committing suicide. And I don't want to focus on that part of the case because it's tragic and I don't really want to necessarily get into the facts of the case per se. What I am very interested in, though, in what came out yesterday in this case, is the way that police found out about this case. That is the most interesting thing to me from a lawyer standpoint. And the way that the police found out about this case is they received a tip from one of the defendants, the male in this, Leon Jacob. He was on bond for another criminal case. And his bondsman was Michael Kubosh, city councilman, who we've had on the show, Julio. He's the one who tipped off the police.
And he went right to the police chief, right?
He was like, hey,
directly to the police
chief.
chief. Hey, I got a live tip here.
Right.
Oh, so
I mean, this was stunning. to
yeah,
me.
it was
The,
to me too.
The bondsman was the one who gave the tip on this thing, and that set in place a series of events wherein they staged an actual crime scene of the murders. They faked the murders, and then sent the undercover out to get the payment. At least that's what
Right.
was.
It was like a restaurant or something, right?
Olive Garden.
Yeah, Olive
Yeah, Olive Garden.
You know,
I don't want to give them the free advertising, but
it was Olive Garden, and
They went for the breadsticks.
I'm reading the article and I'm hearing like the Olive
No,
Garden
I
music
know.
and stuff, and they're making this Olive Garden deal.
you're getting the salad.
Yeah, I mean,
But I am just I'm just stunned that that's how this case went down.
does a bondsman?
What duty does a bondsman owe to their client?
I have no
None?
idea.
Is it
maybe?
none?
Is it to get him to court and that's it? I don't.
Is it to hold anything in
They can't
confidentiality?
have any kind of obligation that I know of.
Well, and is Kubash a lawyer?
That's right. That's the other thing I was thinking.
Because isn't his brother a lawyer?
his brother's a lawyer, right?
And it was.
I think so.
And if I read the article right, the defendant went to him, went to Kubash because Kubash may have had a number of an individual who could have done the deed.
Could have paid money. Yeah.
Yeah, and it is such a twisted story.
It really is. I mean, I've never seen a situation where the bondsman / city councilman is providing the tip to the undercover on this deal.
If that's the case, I mean, if that's the case, we all know. We all know that bondsmen know if their clients are doing things that they shouldn't do, and they don't report them. They don't.
I've
They-
never seen bondsmen
No,
report
they
anybody
never
for
report
anything.
anybody
I mean,
for
besides
anything.
trying to get off a bond, they don't
Sure.
run to the police and tell them
Sure. if they're-
information.
Right. If they're, I mean, unless they're trying to jump off a bond.
I've never seen that ever. But it just blew my mind. Going straight to the police chief? That's crazy.
Straight. And I think Councilman Kubash said.
He's not a lawyer. I'm checking right. He's not a lawyer.
Council.
Brother is.
His brother is.
Yeah.
And I think Councilman Kubash said something of like, I thought he was trying to implicate me in something, and he went straight to the authorities. I'm wondering now if all of their bond clients are like, forget this, man.
Yeah.
I'm going somewhere else.
Yeah. It's crazy.
And so now you have a dream team. I have George Parnham.
Not anymore.
Not anymore.
Not
Not anymore.
Today, Parnham withdrew.
Parnham's off.
withdrew. Parnham withdrew.
And so Paul Morgan's the head guy now.
Yep.
Paul Morgan has one of the biggest cases that's going on here in Harris County right now.
He does.
Yep.
Wow, Paul, you got to come back on the show, man. You got to come back on the show. Parnham withdrew.
He withdrew.
Withdrew today.
I didn't know that.
In his gentlemanly way, he didn't really say the reason why, but
Yeah.
you know, obviously everyone can figure it out. But he's like, I'm getting off of this.
Yeah.
He walked
Read
past.
the news, Julio. It's your job.
I thought I was reading it. I saw him yesterday in that court area, and he came up to me and he looked at me, and I thought he was going to say something like, "You ready? Come in." And I was like, "Put me in, coach." But then he asked me. He said, "Is that your umbrella?" No, but yeah, you can have it, Mr. Parnham. Whatever you want, sir.
Well, I mean, obviously this case has garnered a lot of attention. It had a tragedy to start out. It's now just, this to me has added a little bit more of a twist, bizarre twist to the thing. And I'm sure it's not over with this case.
And you know, Stacey Bond, formerly Judge Stacey Bond, or Judge Bond, we still call her Judge, was the guy's lawyer on the misdemeanor.
On the other case.
And so I guess, so now Paul Morgan's a lawyer on the misdemeanor and the felony solo stuff. Wow. Hey, man, come on the show. I'd love to hear this.
Well, I'm sure you probably can't talk about it.
Well, right. So from what I understand, George Parnham filed a writ to lower his bond or to get him out on bond, and that was denied.
Yeah.
And then the defendant asked the judge to be released
For the funeral.
to go to the funeral, and that was denied too.
Yeah.
Yep.
0 for 2. I know. We'll see where this thing goes. I'm sure this is not the last twist that we're
It's only
gonna
been a
hear
few
about.
weeks, right?
Yeah.
I mean, it feels like all these things have happened. It's only been these things have happened in rapid time.
And we're only at Thursday for this week, so there's still time for more.
It's only been a
crazy
few
stuff to
weeks,
happen.
this whole thing.
Interesting case out of Kansas that I want to talk about. We had the whole deal last year here in Texas with the Securus systems and whether or not those were safe for talking to your clients on. This is nuts to me. The U.S. Attorney's Office in Kansas is now under investigation for spying on over 700 lawyers and their clients while they were in prison, and and basically taking the communications that were recorded by the prison, and I believe they found a stash of all the recordings in the office. Now, I've known, obviously, and most lawyers know, that your phone calls are recorded. And no matter what, whether you say, if you get on the phone and say attorney-client privilege, it doesn't stop them from listening to it.
That always makes me laugh.
I know.
This telephone conversation is hereby protected by attorney-client privilege.
Right. So that's all well and good, and they shouldn't. Only thing it really does is preclude them from entering it into evidence. Okay, because unless you are just live under a rock and have no common sense, you know those tapes get sent back to the U.S. Attorney's Office or the DA's office, whoever's prosecuting. They're listening to all that stuff, and so you just have to keep your mouth shut. And you can't talk about trial strategy. You can't talk about things. It really puts you in a bind, though, if the only way that you can communicate with your client is over a phone.
Is that
And not face to face?
Is that how? And you bring up a good point. And it didn't switch for me. Is that how these lawyers were only able to communicate with their clients over these types of technologies?
I don't know, but it was at Leavenworth, which is,
I couldn't tell from the article either that I read.
Yeah.
It appeared also that some of them were in-person interviews as well.
that
one scares me even more.
Exactly, that was the part of it that was even more scary.
Because I do that all the time, and I'm sure everyone does. And I
Yeah.
always thought that might be some kind of extra level of protection. But obviously that might not be anything either.
Right.
Because apparently they had interviews as well.
Exactly. And look, it's a bad look for the U.S. Attorney's Office for sure. But it just really raises a question for me of, as a defense lawyer, now, what's the real appropriate way to handle this?
Right. And I don't do a lot of federal work, but I know that,
But even
you
at
are
the
in-
state level.
Right, but in the feds, you are in different states, different locations.
Yeah.
That is a way to communicate.
Yeah.
Unless you're getting on an airplane every week to go see them.
Right. Well,
It's got to create all kinds of problems.
Well, and like here, the detention center is up in Conroe. And so, if you need to have a quick conversation with your client about something, you can't, there's nothing quick about going up to the Joe Corley Detention Center, on the north side of Conroe.
Going back to your question, I don't know what the answer is.
Yeah.
You have to talk to them.
Right.
And what are you supposed to do? The mail is out, the phone is out.
In
Now,
person.
in person might be out too.
Yeah, because you can stamp a letter, attorney-client privilege open only in front of the inmate. Okay, but all that does is mean they're just going to open it in front of him.
Right.
Okay, here you go. It doesn't stop it.
They're cheating. The U.S. Attorney's Office is cheating.
Well, yeah. It depending on how they did it. They could be subject to a wiretap prosection themselves.
That's
what
what
it
I'm
sounds
thinking
like.
too.
That's what it sounds like The Wire in reverse.
Right.
I don't, it's crazy to me. It sounds like but then they also took they took what they learned and then tried to obtain evidence from the information that they just eavesdropped on illegally, in my opinion.
Right.
And took it and extrapolated and tried to get more evidence based on what they heard.
And it blew up in their face.
In the U.S. Attorney's Office.
I know. And, we just had that case. And here's the rub, because obviously if a lawyer is participating in the criminal activity, okay, well, you don't have an attorney-client privilege at that point. So if you are going in there and you're talking with your client about, how to...
Whatever conspiracy to...
Right. I mean,
Whatever you're doing.
hey, put all this money in my trust account so the government can't find it, that sort of thing. You are, or whatever further you're going to do. I mean, look at the allegations in the Bellagio case, and how that came to. I'm convinced that is they had a Title III wiretap on Bellagio's client, who was a FARC from South America.
Right.
And they just set up on his phone and intercepted communications between him and his lawyer. And once they heard whatever those conversations, they're listening. And like I said, even if you say attorney-client privilege, it doesn't stop it. And the way to bust that privilege is if you start talking about illegal activity with your client and engaging in illegal activity. I mean, obviously, potentially,
You're talking
about that anyway.
Maybe some illegal activity.
But if you are actually inserting yourself into,
Right.
you got a real problem.
Yeah.
But so I don't know. That what. It's a hard balance, I think, on some of this stuff.
I mean, even aside from it being illegal, violation of rights, the intrusion of the government into citizens' lives, ethically, it's one of the biggest things that we hold, and it's in the highest regards. Look, attorney-client privilege is privilege. These basic core fundamental rights we need to respect. And when we hear of these things at such a vast scale, it's not shocking, but it is shocking. It's one of those things like you don't ever want to know what's in your food, but you know it's there. And then when they tell you it's there, you knew it was there, but man, it sucks.
I mean, I think the problem here is there's no evidence that they went and got a
Right.
warrant to record these phone calls.
And it sounds like there's lots of them. It doesn't sound like it's one time. It's multiple people is the way.
Like 700 or something?
Or at least 700. I mean, this is almost just like, hey, BOP, just give us all the recordings you've got, and we're just going to sift through them and see what we can find. They didn't have a warrant. They didn't have any probable cause to obtain the recorded conversations. I mean, it's just, but you kind of know that going in, because they'll, prosecutors will tell you, hey, we've got the recordings of your client in jail talking to family members and everything. There's nothing protected about that.
Right.
But at the same time, if they've got those conversations, they've got the conversations with you on it as well.
Yeah.
Because you think the jail sits there and parses out which ones are between the lawyer and which ones
No, they just
don't?
give them, it just comes on a CD and they just say, here you go.
Right.
And you start listening to them.
And so as a defense lawyer, you have to have the trust and belief that the other side is, once they hear your voice on there, they're going to stop it and say, I'm not going to listen to that.
And
because I don't have a reason to at this point.
In the county jails, they have the Securus phones there, and you don't have to use them or anything. And I've heard some lawyers don't like to use the cell where the Securus phone is located, because they'll say, I don't trust that thing. That thing's recording. Even though if you're not using it, that thing's sitting there with the recorder, like that microwave, the Kelly Conway and the microwave thing, right? There's a recording going on everywhere. The government's listening to you. And I always thought to myself, you guys are crazy. Just don't use it. You can go use that holding cell, that holdover cell, with that particular telephone in it, but just don't use it. Now I'm thinking to myself, that thing might actually have a recording device inside it, and they're listening to all my stuff.
Well, and
It might not ever go off.
It might not ever. It's just constantly
just on.
recording.
Well,
It's
just on
recording
all the time.
anything.
And after all those the WikiLeaks where they're watching you through the Samsung TVs,
Jeez.
you know,
I'm telling you, man.
They're probably listening to us on our
It's
phones right now,
insane.
listening to our whole show.
Absolutely insane. What, Siri? Jeez.
Yeah, I don't know, man. I mean, it is very troubling. I will tell you that I was involved in a case that had tentacles into Kansas, and I ended up ultimately not going to Kansas. The client couldn't retain me to go to Kansas, but I was involved when the case was looking like it was going to be filed here. And I spoke to the U.S. Attorney's Office in Kansas and about the case. And I will say, in talking to some of the local lawyers up there to try and get a feel, I mean, they did not have good things to say about the office up there. And now this comes out, and I'm just like, wow, no wonder. No wonder they said those things about the office.
How do they know everything we talk about?
Yeah, exactly.
How do they know? How do they know everything? They know my whole strategy, every case.
Right.
How do they know?
Yeah.
Feds, man. Feds.
Yeah. I mean, I don't know, dude. It's blows my mind. Blows my mind that they would do that. We only got a couple minutes left. You got something else you want to
Yeah,
talk
we had a couple minutes. So
What do you want
there.
to talk about in the last 2 minutes, Julio?
Well,
2-minute warning.
Senior United States District Judge out of Nebraska.
Richard Kopp.
Right. He did I guess he was blogging or writing for.
He used to have his own blog. He shut it down.
He puts the top 10 observations of him on the bench, and I think they're good. So let's go.
Is this like your Letterman top?
This is number 10. Number 10. Criminal defense lawyers are at great risk of becoming drunken bastards. Number 10. Because the stress is beyond description. It's true. I mean, we're talking about these.
You're gonna have to pick up the pace.
These
if you're gonna get through all 10
cases.
within 2
Number
minutes.
9. Being a good
got 1
criminal
minute.
defense lawyer requires sincerity, whereas being a great criminal defense lawyer requires the ability to fake it. 8. When it comes to convincing a client to accept responsibility on a guilty plea because it's in the manifest best interest of a client, a criminal defense lawyer must become a client whisperer. Number 7. When it comes to convincing a client to reject a plea offer and take the case to a jury, a criminal defense lawyer, regardless of gender, must possess balls of steel. Number 6. Real criminal defense lawyers don't hate prosecutors, but they certainly don't trust them either. Number 5. Criminal defense lawyers know that a federal judge is never their friend, but the judge is seldom their enemy. Number 4. A tiny fraction of people who have law degrees have the ability to become even mediocre criminal defense lawyers. Number 3. If you become a criminal defense lawyer because you like Rolex watches, then you are definitely an a-hole. Number 2. You must have a big ego to become a decent criminal defense lawyer, but you may not become egotistic. It's never, ever about you. And the first one that I think is completely strong and I believe in is real criminal defense lawyers represent clients, not causes.
And on that note, ladies and gentlemen, I feel like you should have something to throw in the background. But we're going to have to leave you for tonight. For Gary Miller and Julio Vela, I'm Jimmy Ardwan. We'll see you next week, ladies and gentlemen. Good night.